Hello everybody, welcome again to the Ayala Law PA YouTube channel. My name is Eduardo Ayala Maura. I'm the managing partner at Ayala Law. We're a business litigation and business trial lawyers here down in South Florida in Miami. And I want to talk to you today about five reasons why you should have an operating agreement in your company, in your LLC. The first reason why you should have an operating agreement is because you will know who owns what. Let me tell you a story to support that. I had a case where this couple, they weren't married, they just boyfriend and girlfriend, long time relationship. They both built this amazing company, grew to make millions of dollars through over a decade. And then, unfortunately, something happened to him and he had an accident and he passed away. Everybody understood, he understood, she understood, and the employees of the company understood that they were 50-50 owners. Nobody ever challenged that proposition. Now guess when this was challenged? This was challenged once he died, and then the siblings, the sisters, the brothers of the deceased partner of the company started saying, to this person, you are who? We don't know who she is. She's just an employee. She doesn't own anything of the company. And they really had no document, no operating document to prove that she was a 50% owner. She had founded the company actually, and the gentleman came after she founded the company, and then together they built this whole operation. But they didn't have a document to prove it. It gets even worse. When it came to the IRS, when it came to filing their taxes, they would report that he would own 100% for tax reasons because that was their arrangement. So we didn't even have the taxation documents to prove that they were 50-50 owners, even though all of the employees of the company recognized her as the owner. This whole problem, and it became a litigation that lasted 2-3 years. It became a very messy litigation situation, but this whole problem could have been avoided had there been an operating agreement that said she's 50% owner and he's 50% owner. So that is my number one reason, the first reason I tell you, from a business litigation perspective, from a business litigation trial lawyer that sees these things day in and day out, why your company, doesn't matter how big it is, doesn't matter how small it is, should have an operating agreement that clearly states what percentage of the company each person owns. The second reason that I can tell you why you should have an operating agreement is because it will strengthen your entity, it will strengthen your company. In litigation, we deal a lot with arguments related to the company being a sham entity, the company being just a shell that's used to defraud somebody, some third party, the company being just something that you use as your piggy bank. So when you have your operating agreement, all what we call in the law your corporate formalities, your company will be better protected, your company will be more solid. All these corporate formalities, they matter. Even if you are the sole owner of your entity, it is important that you have an operating agreement that says that you are that you are 100% owner of that entity, that you even issue stock, that you issue share certificates that show that then in the Department of State website, you show that you are the member, that you show as an owner. Your tax returns, you show that you are 100%. All of these corporate formalities matter a lot in litigation, so they don't come back to bite you. When we lack that, you're gonna have litigants attacking your entity for not having that, challenging your status as owner perhaps for not having this simple document that you can have. It will also give you good standing with the banks. A lot of banks will want you to have this document, so that's an added benefit. The third reason why you should have an operating agreement from the perspective of the work I do is because it provides the rules of the game. We constantly see owners and partners fighting about, okay, why did you disburse this amount of money? Why did you make this payment? Why did you get into this loan? Why do I not have access to the bank account? Why are we not doing financial reports? Why did you hire this accountant? Like literally, they fight over all these things. And by the way, all of these fights start when there's trust issues. And a lot of these owners at the beginning, they trust each other a lot, and then as things go on, they don't trust each other. So the operating agreement can easily fix that. In an operating agreement, you can provide the rules of the game that says, hey, look, if you're gonna spend more than $5,000, you need more than 51% of the owner's consent in writing. If you're gonna hire a CEO of the company that's gonna make more than $100,000, you need more than 51% consent in writing from the rest of the owner, or you need 75%. You can literally custom-made it however you want, but it's better to have something than not to have something. The common fight against owners that we see in litigation, access to records. The operating agreement can say that every owner has access to the bank accounts, to the financial statements, to the QuickBooks, to the tax returns, at any time. All of the rules of the games can be easily written in a document. It doesn't take a lot, really. And we as litigators, as business lawyers, know what the disputes look like after. We know what partners fight in general. Things repeat a lot. So the fourth reason also relates to what I do, which is how do we split? Your operating agreement should define how are you guys going to divorce from this partnership. And this is a very common problem we see. People have no provision as to what do we do if we don't want to do business together with each other? What do we do if we disagree so much that we can't really come to an agreement on anything and it's affecting the operation of the business? Normally, you should have some process for buyout, and that's how this litigation gets resolved. In some sort of buyout situation where one buys the other one. It rarely happens, especially in the world of small businesses, businesses from $0 to $50 million in revenues. It generally is that one partner or more than one partner will have to buy the other. But you need a process for that, because guess where the disagreement is the strongest in these situations? Price. The one will think the company is worth $1 million, the other one will think the company is worth $10 million. So you need a process to determine, okay, how are we going to appraise the company? Because at the end of the day, when you go to litigation on these issues, that is exactly how it's going to work. The judge is going to order an appraisal of the shares. The judge is going to do that. So you might as well get ahead of that situation and provide for a process. I mean, you could provide simple formulas. I usually recommend the owners, look, match your revenues. If your company makes $10 million in revenues, provide that the buyout is for $10 million, or do a fixed 3 times multiplier on EBITDA, the income before taxation, which is a common term that accountants use. So you can literally provide a formula. It may not be the best formula, it may not be the best deal, but it is the best deal when you look and you talk to me and I tell you what is going to happen in litigation, how long is it going to last, how much is it going to cost you, the stress, the nastiness. You can put all this in an operating agreement. It's easy to write, and it could save you a lot of headaches when you want to say bye-bye to your partner. The fifth reason for having an operating agreement, from my perspective as a business litigator, is what do we do if one of us dies? Do I have to do business with your wife, right, that I may not like? Do I have to do business with your son, who I may think is spoiled, and I don't want to do business with your kid because he knows nothing? So what happens if you die? What happens to your share? All of that can also, you guessed it, be put in the operating agreement. We can say, if you die, if something happens to you, I get to buy your shares at a fixed price. We'll go to the appraisal provision. I am not going to be forced to do business with your wife, with your family, with someone I won't like. Your estate doesn't get to sell these shares to a third party that I may not know. All of that can be, in a very simple way, be written in an operating agreement in a way that avoids disputes. Because at the end of the day, if you go to a court case, if you go to litigation, something similar is going to happen anyway, and you're going to have to settle it, because most people at the end of the day get tired and don't want to litigate for a year, 2 years, because it affects your business. At the end of the day, a business has to make money. A business has to avoid disputes. And an operating agreement is the best way to do that. It is probably repetitive. A lot of people recommend that, but it is surprising to me how much owners overlook this and skip this part of the process. If you like this content, please follow for more. Give us a call if you have any questions regarding business, operating agreements, transactions, and any issues related to business law. We are a law firm in South Florida, in Miami. Ayala Law. My name is Eduardo Ayala. See you in the next time.